I'm the chair of the Holland Hearts Health Law Group. Today we're going to be talking about the new HIPAA reproductive health rule that, barring any court changes, will take effect on December 23rd. Couple of preliminaries. This presentation will be recorded and available for free at our website, should any of you decide to go back in and get more information or share it with others. Also, you should have received a link with copies of materials, including the PowerPoints and an article that I did. If you did not receive that link, you can contact Charles and he can make sure that he gets it to you. If you have questions about any of the things that we're talking about through this program, well, you're not alone. I have a lot of questions myself, but you can go ahead and submit those to me using the chat feature, or you can email me and we will respond to those offline. We hope to cover the following today. We're going to be moving pretty quickly. I'll give you a little bit of background concerning the rule. We'll talk about the rule's main requirements, including the prohibition on disclosure of reproductive health information, and the attestation requirement, and some new rules that are going to come into effect concerning updates to your notice of privacy practices. I'll give you a brief overview of some of the challenges that are pending for the rule and end up with a few resources. Now, my disclaimer. Everything I'm going to talk about today there's a high likelihood that it's going to change over the next couple of weeks. The Trump administration, with them coming in, they may certainly take action against the rule, but more importantly, there's two different lawsuits that are currently pending in Texas against the rule. We anticipate that we will likely get a decision before February 23rd on that. For those of you who follow such things, as you know, the Texas federal courts have not been shy about striking down all or portions of federal regulation if they feel like that the feds have overstepped in those situations. So the bottom line is there's a good likelihood that the things we're going to talk about today may be mooted. In the meantime, however, the Office for Civil Rights has sent a clear message that they intend to enforce the rule until told otherwise. In fact, even though the rule's not effective yet, on November 26th, they imposed some sanctions against a particular entity. Now, they didn't do it under the new rule because the new rule is not effective yet, but they did take action against an entity. A hospital required them to pay $35,000, and they made the point that part of it was because they improperly disclosed reproductive health information. In the course of that announcement, the OCR emphasized that it's committed to ensuring the privacy of lawful reproductive health care. So I thought about just simply waiting until we get the court decision, but figured that I'd probably ought to at least bring these issues to your attention and go through what the rule requires, even if it's struck down here in a couple of weeks, because we don't know exactly what the courts will do. So with that said, let's give a little bit of background. Just to kind of orient us all, remember that HIPAA generally prohibits the use or disclosure of protected health information, unless either the patient consents, give their written authorization, or you fit within one of the consent exceptions, or you have another HIPAA exception applies. There's a bunch of those HIPAA exceptions that would allow you to use or disclose the information without the patient's written authorization, but you have to satisfy certain conditions, including disclosures for things like judicial or administrative proceedings or law enforcement purposes. Now, even though HIPAA allows you to make those disclosures, HIPAA does not itself require you to make disclosures in those situations, although other laws may require you to do so. That's the HIPAA background. In June 2022, of course, all of you know that Dobbs came out from the United States Supreme Court. It overturned Roe v. Wade. As a result of that, a bunch of states passed abortion prohibitions, or those abortion prohibitions that were already on the books sprang into life. The Biden administration didn't really like that, so within days following the Dobbs decision, the Biden administration took some actions to try to minimize to some extent the effects of the Dobbs decision. Among other things, in June of 2022, the OCR issued guidance on HIPAA and reproductive rights. As you remember, if any of you read that, it was kind of interesting. The government said, hey, remember that reproductive health care information is protected health information and is still protected by HIPAA. And even though there are exceptions under HIPAA that would allow you to make disclosures for things like disclosure to law enforcement and the like, you still have to satisfy certain conditions. And perhaps more importantly, HIPAA does not require you to make those disclosures in that situation. Of course, the government didn't necessarily tell you, well, the other laws might, right? The subpoena and the warrant may require you to do it, but the government emphasized that HIPAA did not necessarily require you to make those disclosures. A few days after that, President Biden issued an executive order where he directed federal agencies to kind of look at the impact of Dobbs and take action to protect reproductive healthcare rights to the extent they could. Among other things, he tasked the HHS with reviewing HIPAA to see if there's anything that could be done to protect protected health information concerning reproductive health. For purposes of today, I'm talking about reproductive health information as RPHI, reproductive health information. Under HIPAA, there is no special classification for reproductive health information. It's treated just like other protected health information. But for purposes of our presentation today, I'm going to refer to it as RPHI. So with that task from President Biden, the HHS went and looked at HIPAA. They concluded that HIPAA was intended to promote high-quality care by ensuring patient confidentiality, thereby promoting patient trust and open communication with the health information provider. If a patient doesn't be candid, they may not be candid in their discussions with their healthcare provider, and that adversely affects healthcare on an individual and, according to HHS, on a national level. In the wake of Dobbs, HHS concluded that, at least they allege, that patients are increasingly concerned about the confidentiality of information they share with their healthcare providers out of a fear that their information may be used by or shared with local law enforcement. And that was the justification for the new rule. Specifically in the new rule, the Biden administration was concerned about situations in which prosecutors, agencies, or perhaps even private individuals seek protected health information about reproductive health care to investigate, prosecute, or sue persons for seeking or obtaining reproductive health care that was actually legal where or under the circumstances in which the care was provided. To give it a little bit more context, I happen to reside in Idaho, where abortion is generally illegal. We have one of the strictest anti-abortion statutes in the United States. So if you're a patient in Idaho and you need an abortion, you may need to cross over the state line over to Oregon, where abortion is legal. Well, the Biden administration was concerned about situations where, for example, you have an Idaho patient who goes over to Oregon to get a legal abortion, but maybe you have a zealous Idaho prosecutor who seeks that information from Oregon, where the healthcare, when it was legal, where it was provided, but they seek that information in order to perhaps prosecute the patient in Idaho. So it could apply in those situations where the patient crosses state boundaries to get care where its abortion is legal or other reproductive health care is legal. It could also apply in other situations if the person seeks care that is legal even in the same state. So, for example, in Idaho, at least currently, given some court decisions, abortion is legal in Idaho in the case of EMTALA. EMTALA preempts, or has been held to preempt, at least preliminarily, preempt the Idaho abortion statute in the case of EMTALA. So you might have a situation where a patient goes to the hospital, gets an abortion under EMTALA situations, but yet a local prosecutor wants to get that information so that they can prosecute the patient. The Biden administration and or HHS was concerned about those situations, hence the reproductive health rule. It was published on April 26, 2024. It has an effective date. It actually took effect on June 25th, 2024, but the compliance date, you're not required to comply with it until December 23rd, 2024, so just in a couple of weeks. Now you're required to comply with the general prohibition on disclosing RPHI. There's an additional requirement that will require you, if the rule stays in effect, to update your notice of privacy practices, but the government's given us 2 years to update your notice to February of 2026. So let's talk about the new rule. The new rule applies to PHI regarding reproductive health care. Reproductive health care is defined as health care that affects the health of an individual in all manners relating to the reproductive system and to its functions and processes. It's broader than just abortion. Obviously, abortion was the trigger for it, but extends to any protected health information regarding reproductive health care. It could be, gender-affirming care. It could be any regular types of health care. It would apply to any of that reproductive health care information concerning that reproductive health care. The new rule is going to apply to any covered entity under HIPAA or business associates who have reproductive health care. It's not just those providers who actually rendered the health care, but if you have reproductive health care, either you got it from another healthcare provider, primary care provider, or others, or you're a health plan and you got reproductive health care information concerning your plan members, or your business associate who happens to get this information, anybody, any covered entity or their business associates who has this protected health information concerning reproductive health care potentially has to comply with the new rule unless the new rule is struck down. What does the new rule require? Well, it says that if reproductive health care was legal in the place and under the circumstances where it was rendered, then covered entities and business associates may not use or disclose the reproductive health care for certain purposes. This is a purpose-driven test. It's not just all reproductive health care is protected. That's not the rule. The rule is if you've got reproductive health care information, you can't disclose it for purposes of criminal, civil, or administrative liability or an investigation into that if the care was legal where it was rendered. In addition, to help you comply with that, if the information is sought for certain purposes, administrative law enforcement purposes, those types of things, then you've got to obtain an attestation from the person who's seeking that RPHI to confirm whether or not they're seeking it for purposes of criminal, civil, or administrative investigation or liability to confirm the purpose and the legality of why they're seeking that information. So the ability to use or disclose that information depends upon the purpose for which the person is seeking the information. So let's talk about that a little bit more in detail about what those requirements are. So under the new rule, the covered entity or business associate may not use or disclose protected health information to conduct a criminal, civil, or administrative investigation into any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care. In addition, you can't use or disclose that PHI for purposes of imposing criminal, civil, or administrative liability on any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care, or to identify any person for any of the foregoing purposes. So again, it's not that all reproductive health care is protected or gets special protection. You have to look at the purpose. If somebody comes to you, you have to determine, are they seeking it for purposes of conducting or investigating potential criminal, civil, or administrative investigation. The new rule doesn't apply to other uses. The new rule doesn't affect situations where somebody may be seeking or you want to disclose information for purposes other than conducting criminal, civil, or administrative investigation or cases. For example, under the rule, you can still use or disclose the information for treatment, payment, or healthcare operations, for investigations or prosecutions that are not for purposes of imposing liability simply because you sought reproductive care, or for any other permitted purposes. It only applies if the purpose for the person seeking that information is to conduct those criminal, civil, or administrative proceedings. And it only applies if the reproductive health care was legal in the location and under the circumstances under which it was provided. The reproductive health rule has a rule of applicability. And under the rule, this prohibition, that limit on your use or disclosure of the reproductive health information, only applies if the activity is in connection with a person seeking, obtaining, providing, or facilitating reproductive health care, which is interpreted very broadly or defined extremely broadly. And so that it has to be done in connection with a person seeking reproductive health care, and the covered entity or business associate has to determine that one of the following exist. Either the reproductive health care is lawful under the law and the state law and circumstances when rendered, or the reproductive health care is protected or required or authorized by federal law. So this limitation, the rule only applies if both it involves reproductive health care and it was legal under the circumstances where the care was rendered. Well, what happens if you are not the person who rendered the care? And so how do you know? Well, the rule states that if the care was provided by another person, it's presumed to be lawful unless the covered entity or business associate has actual knowledge that the care was not lawful, or based on the factual information provided to you, requesting use or excuse me, factual information provided by the person who's actually requesting that information, that the use or disclosure of reproductive information, of healthcare information, demonstrates a substantial factual basis that the care was not lawful. Okay. Now, importantly, this is the rule of the scope of the rule is fairly limited. It only applies in these situations. If they're seeking this reproductive health care for purposes of, the prohibited purposes, seeking criminal administrative liability, and if the care was lawful where it was rendered. The new rule does not protect illegal activity. There's nothing that protects you from disclosing, or the government or others from getting information about illegal healthcare if it was illegal in the state or under the circumstances where it was rendered. Now, in order to help implement the rule for certain purposes, if somebody shows up and seeks the information for certain purposes, you have to get an attestation from them to confirm the purposes. Specifically, if somebody shows up and they want the information for usage or disclosures for certain health oversight activities, or disclosures for judicial and administrative proceedings, or disclosures for law enforcement purposes, or disclosures to coroners and medical examiners, if you get somebody seeking that information for one of those purposes, then you may not use or disclose the reproductive care, the RPHI, for those purposes without first obtaining a required attestation from the person seeking the protected health information. So when somebody shows up to want that information, you've got to ask them, well, why do you need that? I mean, that's kind of the way HIPAA works already, right? You can only disclose information for certain permitted purposes. So you'll have to determine, okay, why are you seeking that? And if they're seeking it for one of these purposes, then you've got to get that attestation from them. That attestation has to satisfy certain requirements. There's elements that have to be satisfied. You can prepare your own attestation that has all of these requirements that are set forth in the regulation or on the screen. Generally, your attestation cannot be combined with any other document. It has to be a standalone document. It could be given to you in conjunction with a subpoena or something else, but it can't be combined with any other document. So you can create your own attestation, or the government has prepared their own attestation that you can use. My advice would be to use the government's attestation. So you can go in there and you can download that and have that ready for your people to use if you ever get anybody showing up to seek reproductive health care for any of these particular purposes. Now, they may not specify that they want reproductive health care. Their request may be a lot more broad than that. They may want all of your records. But if all of your records includes reproductive health care and they want it for one of these purposes on the screens, then you're going to have to get that attestation from them. And that attestation will confirm that whether or not they are seeking it for a permitted purpose or a not permitted purpose, and whether or not it was lawful at the time. Now, that's kind of the way that the rule works. I've got some problems with the rule. Not necessarily politically, one way or the other. I don't want to get political on this, but I do have concerns because I represent a lot of healthcare providers, and I don't like the burden that this places on healthcare providers. For example, it forces the provider or business associate to make determinations about the legality of the care that was rendered. So you have to kind of know that. If you didn't provide the care yourself, well, hopefully you know whether your care is legal in the state or in the circumstances that you're rendering it. But if it's care was provided by somebody else, then you've kind of got to make that initial determination. Now, granted, you've got a presumption that helps you that if the care was provided by somebody else, it's presumed to be lawful unless you get contrary information. But it still places you in an awkward situation of having to make that determination. In addition, it forces a provider to fight subpoenas, warrants, court orders, etc., that are seeking that reproductive protected health information about care that the provider or business associate believes was legal. So if you make that determination that the care was legal where it was rendered, and it's for an impermissible purpose, it's for the purpose of the investigation and the like, then the rule says you can't provide it. And the commentary confirms that you can't provide it even if it's a subpoena, even if it's a court order that requires you to provide it. that goes too far. Or at least I've got concerns about that because it puts you in kind of this untenable position. They gave the example in the commentary. For example, a regulated entity receives an attestation from a federal law enforcement official along with court-ordered warrant demanding PHI potentially related to reproductive health care. So you've got this a court-ordered warrant, so presumably signed by a judge. Under the current rule, right? If you get an order or warrant that's signed by the judge, you can just turn it over. You don't have to go against the judge. But in this particular example, the OCR goes on to say, or HHS goes on to say, the law enforcement official represents that the request is about reproductive care that was not lawful under the circumstances in which such health care was provided, but the official will not divulge more information because they allege that doing so would jeopardize an ongoing criminal investigation. So you're there, you've got this warrant, you think that the care may be lawful, or there's a presumption that it was lawful, but you've got a law enforcement official saying, no, we think that it was illegal. What do you do? But they won't divulge more information because they don't want to impact the investigation. So you've got this assertion from them. But what do you do about this? According to the HHS, in this example, if the regulated entity itself provided the reproductive health care and based on the information in its possession, reasonably determined that such health care was lawful under the circumstances in which it was provided, the regulated entity may not disclose the requested PHI, even though you've got a court order warrant there. That's troubling to me. Some of the commentators in the commentary, they were concerned about this. They complained that the new rule potentially puts providers and business associates in situations where they need to choose between complying with a court order and impermissibly disclosing PHI. HHS's response to us, well, that's the way it is. Any burden the attestation may impose on persons requesting PHI is outweighed by the privacy interests that the final rule is designed to protect. That leaves providers in kind of a difficult situation. Are you going to comply with a court order? Are you going to comply with HIPAA? What do you do in that situation? It's going to force you to potentially to go to court and battle with the court, or at least seek further guidance from the court and incur those expenses, which I think is inappropriate. But I'm not the person who drafted the rule. There are some additional changes that the rule made too with regard to some of the definitions. For example, they modified the rules so that person under HIPAA, you remember HIPAA protects the privacy interests of persons, that it only applies to a person means a human being after they were born. Fetuses have no privacy rights under HIPAA. The mothers do, but not the fetuses. In addition, they modified the definition of public health. So if you're in a state that maybe require disclosure of reproductive health purposes for public health purposes, the government was concerned about these states getting around that to use that information in order to prosecute citizens. And so they defined public health, or redefined public health, to exclude activities to investigate or impose criminal, civil, or administrative liability for the mere act of seeking, obtaining, providing, or facilitating protective health care or reproductive health care. So they can't use the public health exception under those particular circumstances. All right, that's a brief overview of the rule. What about enforcement? Well, if you're a covered entity or a business associate, then you can be subject to penalties. The HIPAA penalties, anywhere from $141 up to, $2 million per violation, depending upon your degree of culpability in those particular situations. As I mentioned earlier, the OCR has already sent out kind of the warning shot telling you they intend to enforce the HIPAA regulations in those situations. Now, those civil penalties only apply to covered entities and business associates, the entities that are actually regulated by HIPAA. What about other people, including people who may lie about the attestation or may give false information in an attestation? Well, part of the rule emphasizes that those people, if they misrepresent, then they could be criminally liable under HIPAA's criminal sanctions. Under HIPAA, the criminal statute, it applies if individuals obtain or disclose PHI from a covered entity without authorization, and that could be submitting a false attestation about the lawfulness or the purpose of the attestation, or the purpose of seeking that RPHI. They can get hit up with penalties of anywhere $50,000 fine and 1 year in prison to $250,000 fine and 10 years in prison. So that's what happens if you disclose the information improperly. On the other hand, what do you do if you decide not to disclose the information and the government decides to come after you because you have refused to disclose information in response to a subpoena or under a court order? Well, that could expose you to potential civil, criminal, or administrative penalties, such as contempt. If you've got a subpoena and you refuse to comply, you could be held up for contempt sanctions, obstruction of justice, maybe failure to respond to process, could be any other number of sanctions that could impact that. Now, as a practical matter, if you get a court order or if you get a subpoena that you think that, if the rule's not modified, that would require you to respond, I guess your remedy is to go to court and to seek a modification of the order, or at least let the judge tell you for sure after they've considered the issue whether you have to comply. But even then, you still have the cost of defending against the charges, right? You have to go to court and you have those costs associated with that. You may or may not have insurance coverage for all of that. The bottom line is it just puts healthcare providers in kind of this awkward situation, this tough situation, which is my main reason why I've got concerns about this particular rule. Well, I'm not the only one. As I mentioned, there's 2 lawsuits currently pending in Texas. There's one that argues, the state of Texas versus HHS, that argues that the HIPAA statute doesn't limit how covered entities may share PHI with state government investigators. This lawsuit not only seeks to undo the reproductive health rule, it also seeks to undermine the entire 2000 HIPAA rule to the extent that it would impact this. There's a separate lawsuit that argues that there was no statutory authority for this particular rule, and the rule is arbitrary and capricious under the standards under the APA. Both of those are pending. Extremely likely that we will receive a preliminary decision before the December 23rd, 24th compliance dates. So definitely stay tuned on this stuff. I don't know how those things will shake out. If I'm a betting person, I think that the Texas court, based on kind of their history and what I've seen with kind of what's come out, I think there's a high probability or a significant probability that they're going to stay enforcement for the rule, while given the pendency of the litigation. But who knows? We'll have to wait and see. Even if it does survive that, you've got the incoming administration. They probably don't have the same priorities that the Biden administration did. And I think that there's a good chance that the new Trump administration may change the rule, either affirmatively modify the terms of the rule, or perhaps more likely, just simply choose not to defend the pending litigation. So the plaintiffs win because the new administration just simply decides not to defend it. I don't know. I haven't seen anything from about what the Trump administration would do in these situations, but I think that there's probably a pretty good likelihood that that's the way that it'll shake out. In addition, it could be in the process of the government coming up with the proposed privacy rule changes. Those were published back in 2021. We haven't got the final privacy rule, but the new Trump administration, the new HHS, might decide to modify the new rule as part of these new pending privacy rule changes that we should receive hopefully this next year. As I mentioned, the new rule does place requirements on entities to update your notice of privacy practices to align with the new rule, but the government has said that you've got until February 2026 in order to update your notice of privacy practices. Given the potential change in the rule, as well as the proposed rules that will be coming out, the broader proposed HIPAA rules, that's why the government postponed the deadline. They want to give you a chance to incorporate any changes that come out in the proposed rule, as well as comply with the new federal SUD rules. So I wouldn't be too anxious about updating your notice of privacy practices, but you will have to update those by February of 2026, depending on how the rules shake out. There was an interesting kind of side note in the rule. Under the prior HIPAA rule, it would allow you to make disclosures for certain law enforcement requests, including but not limited to administrative requests. And a lot of times you would have the sheriff's office or police officer coming up there and saying, hey, I want this information. You say, well, I can only disclose it if there's a warrant or a subpoena. And they say, well, I'm making an administrative request. And they would tell you that because it's an administrative request, you can go ahead and provide it. Well, that's not what the rule was intended to mean. it was intended to mean only those administrative requests that you are required by law to respond to, not just because a police officer shows up there and asks for the information. The new reproductive health rule did clarify that, so they make it clear that the exception only applies to an administrative request for which a response is required by law, not just simply because a police officer asked for the information. All right, that's where we are in the new rule. The government has published lots of information out there to try to get you to comply with the new rule as late as December 5th. They sent a letter to, or send out an email with a bunch of compliance resources concerning the new rule. You can go to this website and you can access a whole bunch of information about the rule, including things like the press release, the summary of the final rule, the fact sheet that OCR implemented. There was a webinar that was also held that you can access. You can access the slides. All of that's available on the OCR's website. In addition, we have additional content, including an article that I drafted on our website that you can access. There it is. That's the new rule. Bottom line is stay tuned over the next couple of weeks to see where we're left by Christmas. But in the meantime, if you have any questions about whatever I talked about, feel free to shoot me a quick email and I'll try to respond offline. Thank you for your participation today, and I hope it's helpful. If we don't communicate before, I hope you all have great holidays.